your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And David Whiting is here to answer your legal questions. He is a Melbourne solicitor. So much in such a simple word. Good morning, David.
Good morning, Raph.
Any homework?
I did. I had it was a great call. It was Les from Doncaster. He's 90. He has a 65-year-old son who, in order to get a Centrelink benefit, needs to be on a job seeker allowance. And the normal job seeker allowance requires you to apply for a certain number of jobs every particular period, every fortnight, and provide details to Centrelink. Now, a couple of months ago, the son got an exemption for a period of 3 months because of his significant health issues. And then he got a notice, no, changed our mind, you've got till the end of the month and then you must start looking. And it was Les's view that his son was in absolutely no condition to either look for jobs or take a job if one was offered. So the question was, what's the process? We got some text message that says lodge a complaint. Technically, you seek a review of the decision. And it's an internal review done by someone other than the original decision maker. And if you don't like that decision, or if the decision stands, then you go to the Australian Review Tribunal and they take it from there. Right?
Okay, sounds like a difficult
fairly simple,
process.
straightforward. Yes, it's a complaint, but it's called a request for a review.
A request for a review. Okay.
Yes.
You think it's simple and straightforward. Sounds painful to me. We'll leave it there. Let's get to a question from Marianne, who is calling from Burwood. Marianne, go for it. What's your query?
Oh, hi, David. Thank you very much for taking my call. I live in a 3-block unit, single story, and my middle neighbour, who moved in November, is currently continuously blocking the driveway. The other day, I asked the van driver to kindly move his van, and she got quite aggressive, and she told me in a very harsh tone just to wait. And I had a medical appointment. Then on Thursday, she blocked it for about an hour. Now, I need to know what my legal rights are and is it illegal to block a driveway?
You've got to understand, Marianne, that legal is breaking one of the state's laws or rules. So It's not the owner's corporation rule, it's a state law that you break for it to be illegal. It's a breach of the obligations that exist under the Owners Corporation Act, but it's a 3-unit development. You've got to... Yes. The process is running a dispute at VCAT.
Oh, VCAT.
Yeah, and we just, it just seems to me to be remarkably disproportionate. You could start parking your vehicle a little further down the driveway if you wanted to play the same game as the owner. No, but I imagine he's moving. I imagine the person's moving. They'll be gone soon.
No, they're not moving. She has constantly deliveries. That's what she has. Constant deliveries delivered to the unit. Yes. And the other day also and I've been aware of this for a little while, she's been using my rubbish bins to put her rubbish in, and she's put illegally in one of my bins things that should not have gone into the bins. And I allowed it to go. So I am now going to have to be a little bit smarter and work how to prevent her from using my bins as well.
What legal? Just one tick, Marianne.
Yeah, sure.
What legal steps can she take? Are there any? You don't see.
Oh no, there are. The answer is you can issue, if you have a dispute with the Owners Corporation, there's a process in the Act for bringing it to the attention of the Owners Corporation, but then it becomes necessary to get some kind of court injunction to prevent an ongoing breach of the arrangement.
Right.
And it just strikes me as hideously disproportionate from Marianne's point of view in terms of the effort and costs that she will go to achieve the objective.
Okay, Marianne, I think that's your only option.
Okay, thank you very much. Appreciate it.
Good luck. Good luck. Sounds really painful, Marianne, and I'm not sure the law is going to be a solution, but good luck. Peter's calling from Upwey. Peter, what's your question?
Good morning, David and Raph. David, I bought my house 16 years ago, at which time the previous owner disclosed that he'd built a large shed at the back of the property without a building permit. I have built a carport myself without a building permit in the last 5 years. do I need to disclose both in the Section 32 to the prospective buyer?
Well, the carport, the shed was built by somebody else, not on your property, was it?
No, it was built on my property 15 years ago by the previous owner from whom I bought the property.
Do you know
without a building permit?
But do you know if 15 years ago a building permit was required for the shed?
No, I don't know.
Right.
But
there is a. We get these. Section 12 of the Sale of Land Act requires you to make disclosure to a purchaser of anything that you think a purchaser would want to know. All right. So I would say that Section 12 requires you to disclose both.
Right.
Right.
And what are the consequences if I don't?
There haven't been any prosecutions yet. The provision's been in about 4 or 5 years. It's illegal to not make the material disclosure, but as I said, no one's been taken to task. It's illegal
to not disclose.
It's illegal to not disclose. So, but it doesn't give the purchaser any rights.
Yeah.
So,
he can't pull out.
Sorry?
He can't pull out of the agreement if I hadn't. He can't say, listen, you didn't tell me that you built an illegal carport. I'm pulling out of the contract.
No.
Ah.
But I do think it's appropriate to tell the purchaser that the shed was 15 years ago, and in respect of the shed, because of its age, there would be no expectation that there would be a certificate of final inspection because of its age. But you built the carport in 5. There's an expectation that you built. So why would you not put a line in that said, I built the carport without a permit?
Right. And that covers you.
Well, I want you to make full disclosure. I mean, the purpose of the Section 32 statement, the vendor statement, is to enable the purchaser to make a fully informed decision. You would want, if you go and buy another place, you would want your vendor to be less
honest,
devious than you look like you might be going to be.
Yeah.
Okay.
Yeah.
Does that answer your query, Peter?
Yes, it does. Thank you, David.
Okay, good luck.
Thank you. Okay.
Whenever those things come up, David, it always seems to me the Section 32 is more about transparency than prosecution.
Yes.
That might not be its intended effect.
There has been no prosecutions under Section 12. Yep.
Yeah. Peter, it's an interesting one. Thank you for calling. Natalie is in Northcote. What's your question about, Natalie?
Hi, I'm calling about stratums versus stratas and wondering whether the Owners Corporation Act still applies to stratums.
Yes.
Great. And then how do you enforce the rules of the Owners Corporations Act in relation to access to records and preparation for annual general meetings? Is it only through VCAT?
The answer to that question is yes. You have a right. What you've got is you've now got a right against the service company in your stratum structure.
We don't have a service company. It's just people, and they're pretty nasty.
Then you have a strata system.
They swear at me.
Then you have a strata. How old is your building?
It's 1968. It is a stratum. We report through ASIC.
Then you have a service company. Otherwise, you wouldn't be reporting to ASIC.
Oh, okay.
So it might be XYZ Proprietary Limited.
Yes. So the service company is controlled entirely by the owners.
Yes. So
there's
you will have
external company involved.
You will have a title to your unit, and attached to your title will be a number of shares in the service company.
Yes.
Okay. Now, but the Owners Corporation rules apply, and the process for complaints in the Owners Corporation Act apply. Now, there is a requirement in the Owners Corporation Act for we'll call it the Owners Corporation, but really in your case it's a service company, to provide you with records.
Yes.
Yes.
I have requested the records many times and not been given
And if they do not provide the records, then it's to VCAT for an order that they do so. Or alternatively, that an administrator be appointed to the service company.
Okay. And would that be true also for things like preparing for annual general meetings and like making sure the financial statements are available ahead of the annual general meetings?
The problem, Natalie, is that the owners, how many units in your block?
23.
The problem is that a block of 23 units in Northcote is governed by the same piece of legislation as BHP operates under.
Yes, it's
1,200 pages of very tightly worded clauses. I think it's unreasonable to expect that the standards to which we hold BHP are the standards to which we will hold your service company.
But is there not something in the Owners Corporation Act about preparation for annual general meetings? Because I'm looking at the Consumer Affairs Victoria website.
Can I suggest that you download the Act from legislation.vic.gov? Beg your pardon?
Which one, sorry?
I want you to download the Owners Corporation Act from and the Owners Corporation Regulations from legislation.vic.gov.au. Now, the stuff you get on Consumer Affairs website is good, but it's a high-level summary.
Okay.
And everything that you conclude from the high-level summary might not match the specifics of the legislation. So look at the rules and look at the Act and then form your view about precisely what's required.
And the only real legal recourse is VCAT, is that correct? Okay. Natalie, good luck.
You could, because it's against the company, you could issue a proceeding in the federal court, which is we're now starting to get horribly. It's a claim under the Corporations Act.
Right.
It's starting to get hideously expensive.
Yeah, federal court. That's not cheap lawyers.
No.
Natalie, good luck. Sounds painful. Lisa is calling from Baronia. Lisa, what's your query about?
Hi, Raf. Hi, David. Thanks for taking my call. I have a couple of separate sort of queries. We bought a new caravan in June of this year, and when we bought it, it weighed 240 kilos heavier than what was advertised on the website.
Was that because of things you added to it, Lisa?
No, we didn't add anything. We changed the layout of the inside. Where instead of an L-shaped booth seat, we changed it to cafe seating.
And does that does that mean that more stuff needs to be structurally put in the caravan?
No, it doesn't, because I think it's built the same. We just sort of customised the layout a bit.
I want know, Lisa.
Okay.
Right? Now, every time you make a change, there is a consequence. Now, so my question is are you saying that the weight of the caravan, which is important from a towing perspective, was wrong in the website, or is it wrong for some other reason? I mean, have you now filled the tanks, for example?
No. So the reason we bought the van is because we had a really large payload, which is what you're allowed to carry with you. And we actually had that payload reduced by 30%. So it dropped down to 560 instead of 800. And they're sort of saying, oh, you customised it and it's the materials from our factory and it can cause lots of different things to weigh. But that's a huge discrepancy.
Which is they're running my argument. Right? But what I'm putting to you is that it's changes that you've made have added to the weight of the vehicle.
Yeah, that's right. And so is there any way that we'd be able to say it didn't match the product description on the website and kind of argue that further?
But you've customised the web description on the website. So what you need to do, I mean, I suppose your point is that it may well be that the modifications that you made to the vehicle added to the weight. Let's not worry about how much at the moment. The question, what you need to do is establish that the caravan with the weight disclosed on the website was wrong.
Yes.
And yours is not the model. The model that you would have to find and weigh is the model without your modifications.
Mm-hmm.
Yep.
Does that make sense?
And then we get to the question as to whether or not, you know, if it's different by 20 kilos, is that a significant breach that would enable you to do something material about it? I don't know. You know, if we're changing 1% in weight of the caravan, is that something that would enable you to send the caravan back? Wouldn't have thought so.
Not for 1%, but this was 240 kilos over. 240 kilos over.
Hang on.
Yeah.
It's 240 kilos more than the weight disclosed in the website.
Yes,
but
that's
we
right.
haven't yet worked out
If the website one's
whether
one
the
you bought.
website was right or not.
It was incorrect, and then when we told them about
Sorry, no.
it was changed.
Sorry, but you haven't weighed a caravan that matches precisely with what's in the website.
So if maybe I can short circuit it this way, David. If she's got this disagreement with them, what does she need to do to have a
The starting
proper
point has to be weigh the website, weigh a
the one on the
caravan
website.
that's identical to the one that they've disclosed. And let's say that that's out by 200 kilograms or out by 150
Then maybe you've got
kilograms.
an argument.
Then I think your argument's quite strong. The other thing that for people like Lisa in that situation, is to make it abundantly clear to the people you're buying from precisely what your requirements are. You know, if you like, imagine you own a coin operator, commercial laundry, and you go into one of the majors and you buy a small domestic washing machine with the expectation that it'll be good for 40 loads a day for 10 years, you're going to be disappointed. Yeah. So Lisa, you need to come along and not just do your calculations, but explain your calculations and your end game, and tell them that when I get it, it needs to weigh less than.
Good luck, Lisa. I hope that's given you some guidance. I'll be back with more calls for David Whiting in just a moment. Full board of calls. David is first up for David Whiting, and this David's calling from Malvern. What do you want to ask?
Hi, thank you for the call. I'm ringing regarding
Oh,
vehicle
David.
that I own, which my insurance company wishes to write off, and I believe that it's not appropriate. So my 14-and-a-half-year-old Peugeot was hit by a share ride driver, and it's sustained some panel damage to the left-hand side.
David, it's actually very simple, right?
So,
the insurance company does an assessment and they say, what's the pre-accident value of the vehicle? And that's an objective value. It's not subjective from David's love of a 14-year-old Peugeot, which I confess I could understand, right? Yep. And what it's worth in its current state and what's the cost of repair. If current value plus cost of repair exceeds the market value of the vehicle, then from a purely arithmetic exercise, it's a write-off. Sorry, no, hang on. It's not a write-off. It's not an economic repair. They're not going to give you back. They're going to spend too much money to get you back where you are now, where you were before the accident.
And if you disagree with the write-off?
Then you can turn around and say, well, I'll take the write-off at that value, just give me the difference. And if you can find someone to repair it for you, David, you're there.
sorry,
But you'll probably need...
write-off.
Beg your pardon?
Yeah, they're claiming that they're going to put it on the write-off registry.
Yes. And that's fine, but you then need an engineer's... And they're obliged to put it on the register. And you then need an engineer's certificate that says it's okay. Now, if I can give you an example, some years ago, remember, 15 years ago, we had, about the time you bought the Peugeot, we had this monstrous hailstorm. And there were lots and lots of cars that looked like somebody had danced on them with high heel shoes, right? Now, from a insurance company's point of view, a lot of them became uneconomic to repair because of the amount of work required, but none of that affected the roadworthiness.
Yes.
So you're potentially in the same situation. They've come along and said, and these are figures that I've just made up, David, that the car's worth 10 grand before the accident, right? It's now worth 2 and the cost of repairs is 9. That's 11 grand to get it fixed.
Not worth it.
Not worth. Why would I invest 11 grand in a 10 grand car?
But if he takes the money and get an engineer's report.
You take the money, you take the car, you get it repaired, and you need an engineer's certificate before Vic Roads will let you put it back on the road.
Does that make sense?
They won't give me the car. They take ownership of the car when it goes on the register.
Well, why don't you buy it from them?
Because I have to pay the salvage cost, and I have to get it re-registered.
But David, that's
significant fees associated with that.
They have formed the view that it's not an economic repair, so it comes They take the process which the law requires them to do because the government doesn't like rebirthing of cars that are not safe. You're on the edge, you've got caught. If you particularly want that car repaired, that's the process you need to follow. And if you look at the terms of if you look at the product disclosure statement prepared by the insurance company that you've signed up to, they're the rules.
Sorry, David, probably not the news you want to hear, but I will leave you with that and we will see if we can squeeze in Harry, who's calling from Kyneton. What's your question about, Harry?
Oh, g'day, Raf, David. My daughter's doing year 12 and catches the V-Line train to Bendigo 5 days a week. We paid for an annual ticket, so $700. She boarded the train. The inspector came on, said, "Give us your Mikey," and she'd forgotten her Mikey that day. She said to the guy, "Here's my card, which shows my photo ID and proof of purchase of my annual thing," and she's been fined $300.
Yep.
That doesn't sound good.
No, Harry, the fines for not using the ticket to travel. The fine's not for not having a ticket. So I come to work on the tram. If I don't tap on, if I leave it at home and I get pinged by the authorised officers, which seem to get up very early, I must say.
$300 fine.
It's a $300 fine. Have I been pinged yet? No, not yet. Well, anything will happen. And if I leave it in my pocket and don't... Sorry?
You didn't have proof of purchase in your pocket, though. She
No.
did.
Yeah, but let's be really brutal, Harry. She might have lent it to a friend.
Right.
It's
a photo ID, mate. Photo ID. It's a photo ID.
But it's not, and I've never seen your photo on your driver's licence. Does it look like you or somebody else, Harry? Anyway.
It looks like a very young me, yeah.
Yeah, okay, we all have that. Very good, Harry. Right? But the test is you've got to tap on. If you don't tap on, you are riding a vehicle without meeting the requirements of the ticket.
The final quick rejoinder is the appeals process seems to rule out any potential to actually appeal this. All the criteria that are listed don't cover this issue.
You can go to court and have an argument about what the penalty ought to be.
Right.
But that strikes me as being
not having
way
the ticket
over
means
the
you
top.
don't have the ticket.
No, sorry. No, you can have a ticket. It's whether you tap on or not.
Oh, okay. Yeah, well, yeah, you haven't.
So if you haven't tapped on,
then you haven't done the thing.
Then you haven't done what's required.
As Raf would say, it's a bit harsh.
Well,
yeah.
What else can I say? $300 is more than a bit harsh, though, isn't it?
Oh, it's very harsh. But we have a government that's desperate for money, Harry.
Thanks for that.
Okay.
Good luck, Harry.
Thank you, Raf.
David was hanging judge. David, a hanging judge Whiting today. There you go.
That's grossly unfair. But I'll come back next week.
Come back next week, kinder and gentler. David joins us every Tuesday to attempt to answer your legal quandaries. If there's a question he feels he can't answer, which was not the case today, he will give you his homework after the 10 o'clock news. That's all coming your way next week, Tuesday after 10.